For those of you who are accountants and businessmen, you will know that we have in him one of the finest advocates who has practiced before the High Court and the Income Tax Tribunal. His own knowledge of laws and especially tax laws is extremely deep. Come, Percy. Why don't you pick up some tea and snack and then sit down?
Thank you.
A very, very competent lawyer with deep knowledge of tax laws and advocacy par excellence. Mr. Dastur today rules the world of tax litigation. He is the most sought after tax advocate in Bombay and the Supreme Court, and obviously in the Income Tax Tribunal all over the country. And most important, he epitomizes what a perfect gentleman ought to be. Unimaginably so. I was talking to some of my colleagues that if you wish to learn to what a good professional ought to be, learn from Mr. Dastur. All of us who have been practicing tax keenly watch what Mr. Dastur does. He argues and what he brings by way of eventual judgments and orders of the tribunal. I'm so happy that he has agreed to come and talk to us on a topic which I think would be of great interest to all of us, which is the rule of law. I'm also happy to have Mr. Percy Padiwala with us, another very, very successful and very sought after advocate, a colleague of Mr. Dastur who has come and joined us now. Thank you so much. Can I ask, where is Avni? Come, Avni. Would you like to offer a bouquet of flowers to Mr. Dastur before he starts off? All yours, Mr. Dastur.
I was told that one of the things which Manthan promotes is truth and search for truth. I'm glad that in the last 10 minutes you have sacrificed that aim and have said so many kind things. The rule of law, what is the concept of the rule of law? It is not just a legal concept for lawyers. It is a concept which affects all of us, a concept which governs or should govern our living. It is not just a rule of interpretation which you would have in legal discussions. It is something which has an impact on our actions, our way of living, and our ability to enjoy life. The rule of law is distinct from, if one may say so, the rule of man. Because the law is all-pervading, the law overrides the actions of individuals. At the same time, it is an amorphous concept. You cannot put it down in a cage, well, this is a rule of law. But that is why it has so much great relevance. It is, however, though one cannot have straight jacketing of the rule of law, it has still certain basic concepts. It is not like the old rule of equity, where they used to say that the concept of equity varies with the foot of the Vice Chancellor. Some have a large size, some have a small size. But there are certain basic things which the concept of law achieves. It is, the first principle I think is that no one is above the law. The law is absolutely supreme. It doesn't listen to influence, it doesn't listen to power. It is equality before the law and equal subjection to the law. Unfortunately, we who call ourselves a socialist country have sometimes the most feudalistic outlook. We who govern us want to have privileges. A minister of state who is not entitled to be above frisking at an airport will insist that no, I must have that privilege also. A minister of state who may not be entitled to sit in a room reserved for very, very important people will say, no, I am as good as that, I must be able to sit there. And what is tragic is that thereafter he manages to get the rules changed so that he is also above frisking. So this is not the rule of law, it is the rule of a person who wants his own importance. Take another example. The rule of law says everybody must be equal. Yet, when a great cricketer, perhaps the best cricketer today in the world, wins a prize in a contest and wants to bring home his car, customs duty waiver is given. For lesser human beings, that is not so. Why should that be? That is not the rule of law. You have the example, I think one which stood out, that Tony Blair ceased to be the Prime Minister of England, and in the evening he was at the railway station with his bag in hand getting into the train. Can you imagine that happening in India? Where people will go out of the way to say, I must get Z security, which costs the country crores of rupees. I'm not saying that security is not necessary, but one must draw the line as to what is absolutely necessary for a person's safety and what is insisted upon as a mark of greatness or a mark of distinction. You must have heard of Lester Piggott, those of you who are horse racers, even though you may not be betters. Lester Piggott, Sir Lester Piggott, he won the Derby number of times, as great as Gordon Richards. Lester Piggott was convicted for a tax offence. He went to jail, spent 6 years there and came out. There was no cry that no, Lester Piggott cannot go to jail. In our country, there is cricket match fixing, and somebody who is very high up, who has done a lot, who has captained the World Cup when we won the World Cup, he is accused, he comes on TV, sheds a few tears as to how much he has done for the country and now what is being happening to him. And everybody comes up, no, how can you have anything against him? But it's quite different what a person does on the field, and if he has done something wrong, he must pay for it. That is the rule of law. We cannot be swayed by these false sentiments. It is, you must have parliamentary privileges. I'm not saying no. But then they must be such as are absolutely necessary for that person. One must realize that if one is in a democracy, one is as good as another person. And one cannot insist on privileges more than those who vote that person into power. Everybody wants some aura of distinction. I am sometimes reminded of what Cicero is said to have once said. He was asked in Rome that there are statues to Caesar, there is a statue to Pompey, who Caesar defeated. But there is no statue to Cicero. Why? And he said, well, I would rather people asked why there is no statue to Cicero than they asked Why is there a statute of Cicero? So this is, I think, the question of rule of law, rule of equality. A question of rule of law is the state bound by the law? Or is government bound by the law? The answer in India certainly is that yes, the state is always bound by the law. In England, on the other hand, the rule is slightly different, the most democratic country, that unless the law says that the state is bound, he is not bound. But then in England, by the state you don't mean the ministers. By the state you mean the king or queen of England. So therefore, the state is always bound unless specifically exempted or necessarily exempted. What do we mean by necessarily exempted? The state or the government is not liable to pay income tax. Why? Because income tax goes into its own coffers. So one person paying out something from one pocket and putting into the other, it is not bound. But if there is, let us say, some municipal law which is to be observed, and that is not observed by the state, you can recover penalty from the state for not observing that municipal law. Let us say the state is the owner of a building and there are tenants, and the tenants have a right of purchasing the building. The state is bound to sell that property. The state cannot say, no, I will not sell, I am not bound by this law. So therefore, the state is always bound by the law. A question which arises about the rule of law, what about morality? Supposing an action is not moral, but within the four corners of the law, what should happen? A very ticklish question, because there is a point of view that morality must prevail always. But then, if you take that view, it will mean that justice and law will be guided by what a person personally feels about morality. Because the question of morality is a personal question. So, I would think the position is, if the law regards and if the law allows you a certain privilege, if the law allows you, let us say in tax, a certain deduction, then it must be given. One cannot then sit in moral judgment that is this proper, is this not proper. It is the law which will decide whether it is proper. I'll give you a very recent example. There was a Dr. Qureshi in Madhya Pradesh, and he was found in possession of heroin, and that heroin was confiscated. In the income tax proceedings, he said, I must get a deduction for the value of this heroin because I am in the business of selling heroin and this is a business loss. There is a provision in the Act which says that if there is an expenditure which is illegal, you will not get it. But the Supreme Court said, no, expenditure is different from a loss. An loss is something which falls upon you. An expenditure is something which goes from your pocket. So this is a loss. We don't approve of the activities of Dr. Qureshi, but he is entitled in law to get this deduction, so he must get it. The Madhya Pradesh High Court, on the other hand, had gone into a prolonged moralistic lecture into how heroin affects young people, how it affects their lives. But the Supreme Court said, we don't approve of his action. But if this is the law which is laid down, then we must enforce that law. That is the basis of law, enforcing the law without going into moralistic discussions. Question arises, is the rule of law peculiar to a democracy? Can you have a rule of law in a dictatorship? I would think yes. One may not approve of the dictatorship, but if the dictator is on the same footing as the person to whom he dictates, if he is a dictator who is a benevolent dictator, then I do not see why one can say that the rule of law does not prevail. There are examples in history. Ataturk, he was a dictator, but he was the person who brought up Turkey. Some would say Perón in Argentina, he was a dictator, but he was, in a sense, a benevolent dictator. And therefore, a rule of law is not something peculiar to a democracy, though more likely to exist in a democracy than in a dictatorship. There is also a changing concept of the rule of law. People used to think, and Dicey, a very great jurist, used to think that administrative law means that there is no rule of law. The rule of law must be by courts and not by tribunals. That was the old view. He himself later on in his life recognized that yes, one can have the rule of law which is administered by tribunals. And today it is accepted in our constitution, in Article 323, A and B, that you can have tribunals. In Article 323B, the tribunal decision by the tribunal under Article 323B is final except for an appeal to the Supreme Court. So it is quite outside the normal civil jurisdiction which prevails otherwise. So therefore, there is always, today everybody accepts it. In late 1850s, in England they did not accept it. In France they always accepted it. France is the starting point of all administrative law. Therefore, there is a changing concept of what is the rule of law. Take another thing about the rule of law. You don't agree with the law. Must you follow it? Or would you say, no, I will not follow it? Sort of satyagraha. But there was a man of great moral standing who practiced it. We are all not capable of doing it. We all will look at it from a personal point of view. And therefore, I would think if one accepts that one can ignore the law, yes, if you are strong enough, ignore it. But if a penalty is put, one suffers that penalty, as Gandhiji did. So, but then what happens when that comes? People start squealing. No, why should that happen? So therefore, if one wants to defy the law, one must do it on the perfect understanding that breach of that will be visited with certain consequences. Now, what are the attributes of the rule of law? I would think the first attribute is that no man is punishable or can be made to suffer for a breach of the law unless the breach is established in ordinary manner before an ordinary court of law. Of course, there is now a slight modification. This is what the Supreme Court laid down. There is a slight modification now. People do accept special courts, but the Supreme Court insists that that special court must have certain basic safeguards, so that in that special safeguard, a person is not deprived of his rights. Again, there are provisions, particularly in revenue laws, where one discards the basic principle which was sought to be of rule of law, that is, the burden is on the state to establish that he is guilty. But then there are provisions in the Income Tax Act, in the Customs Act, that the burden is on the SSE to show that he did not have a guilty mind. The burden of proof is shifted. Again, that is a recent development, but one cannot say that is not in accordance with the rule of law. Then there are this presumption of innocence, as I say, normally applies, but in certain circumstances where the law itself provides, it will not apply. Again, the Supreme Court stated in Chattar Singh versus State of Rajasthan that the rule of law means that it establishes a uniform pattern for harmonious existence where every individual is free to exercise his right to his advantage, but with one rider, subject to protective discrimination. And that is this protective discrimination we see when quotas are fixed and reservation made. Everybody is free to pursue his advantage, but in certain circumstances there will be a protection given to certain communities, to certain people placed in certain circumstances. The rule of law, I think, is embodied, if one puts it, in Part 3 of our Constitution about fundamental rights, and particularly Article 14 and Article 19 Article 14, which the Supreme Court has given the widest possible meaning, which speaks of only equality before the law and equal protection of the law. But the Supreme Court has read into it that there must be fair administration. Supreme Court has read into it that a law must be reasonable. An unreasonable law may breach Article 14. A law which places excessive restrictions will breach Article 14. Article 19, which gives us freedom of speech, which gives a person right of assembly, that is, I think, again, one of the cornerstones of the rule of law. The rule of law is, again, that every person, this is Article 19, every person has a right to move about any part of India, to settle in any part of India, and to work in any part of India. That is Article 19, fundamental right. But you find there is a state from which I come where people raise the bogey that no, you are not from my state, so you should not work here. You should not have this privilege. Goes contrary to Article 19. Yet, who enforces it? Does the state have the courage to do it? But look at contempt of law. Arundhati Roy says something about the Supreme Court, they haul her up for contempt. Mr. Thackeray, I'm sorry to use names, says the most abusive things about judges, but nobody hauls him up. This is where one loses faith in the rule of, there is a rule of law, but there is no enforcement of that rule of law. A person who can create mob hysteria, yes, the state does not think he's strong enough to meet that person. And that is where one loses respect for the rule of law. And I think if one loses respect for the rule of law will not prevail. The one attribute of the rule of law is that every decision, whether of the executive or of the judiciary, must be based on known principles, and the decision should be predictable. Because unless it is predictable, how will you follow that? How will you be responsible for it? Again, one does not here deal with complicated issues in complicated laws, where of course the decision may be predictable, may not be predictable. But one feels that generally, things which affect one's life and liberty, the decision should be predictable and it should be known. There must be absence of arbitrary power. There must be transparency. And I think the one thing which has introduced that and ensured it is the right of information. The right to information one can apply for, get information, and that means that makes that person accountable. And that is the next step. Accountability is the basis of the rule of law. Accountability by the executive. One should have accountability also by the legislators. For example, if out of 30 days of a parliamentary sitting, for 12 days parliament doesn't function, then there is no accountability of our legislators. There should be accountability of the legislators in the way they function. There should also be some accountability on political parties. You lend support to some party to form a government, and thereafter you withdraw support without reason. You agree that you will be the chief minister for 6 months, and for the next 6 months so and so will be the chief minister. At the end of your 6 months you say no, because of certain reasons I am not bound by it. But if there is a commitment, the rule of law requires that that commitment, whatever type it is, political, economic, must be honored. Take another case. An airport is constructed in Bangalore. When the terms are negotiated, the constructor is told that we will shut down the old airport, you will be entitled to levy certain charges. Airport is constructed, new airport is there, and then a movement starts that we should continue with the old airport. These charges should not be there. Is that the rule of law? And ministers come forth and say, no, we will negotiate. But you can't, because the state is powerful, you cannot say we will negotiate because that person must cave in at some point of time. Unfortunately, even the High Court says it is a matter which this party should resolve amongst themselves. But the High Court should have said, in my view, that the rule of you have made certain commitments, unless you show something that commitment was extracted or commitment was given under some undue pressure or given under some corruption. You must honor that commitment. Otherwise, what is the consequence? Every person who now negotiates for an airport will say, yes, I'm getting these terms today. Tomorrow they will insist on something else. So let me jack up my quotation by at least 15% to provide for this contingency, which means the nation suffers in it. Just as, common example, you normally go to a shop and bargain. Your first occasion you will succeed perhaps. But on the second occasion, he is going to jack up his price so that all the bargaining that you do will ultimately mean that you are still paying perhaps more than what he would have otherwise quoted if you were not a bargainer. So this is the rule of law, and every governmental action must be authorized by the law. Government has vast powers, but it must be authorized by law. There is a power in England that the minister can censor anything. But the minister never oversteps his limit because there is a democratic tradition. There is a law that you can acquire property, but obviously it must always be within the four corners of the law. The basic principle of law, the basic structure of the law must be always followed. Then there is a question about if there is a law which is repugnant to the standards of morality accepted by civilized society, is that the rule of law? There was apartheid in South Africa, sanctioned by law. Parliament had passed the law. But can one say that this is a rule of law? Again, the answer, I think there is that higher principle of civilized society, not one individual, but what is repugnant to the thought of the civilized society as such. Then, the law must obviously be published. You cannot have a law which is not published. You cannot fish out a law from the drawer and say, this is the law. Law must be always in present time. That is, if you have legislation which is ex post facto, legislation which undoes the past, then such a legislation is against the principles of, normal principles of accepted rule of law. It must be prospective. However, there is a case where perhaps grave injustice may be done if it is not made retrospective. But you cannot have retrospective legislation as a rule. Again, this happens primarily in revenue matters. Law is framed, the court takes a decision, the Minister of Finance feels that this is not in accordance with what they intended, so retrospective legislation is passed. But the normal rule of law is, if you feel that what you have stated is the correct law and the court has misinterpreted it, carry it up higher. Don't take the easy way out of making a retrospective amendment. It is like in a cricket field. Because you don't approve of an umpire's decision, you want it changed. Or you don't approve of what has been done, you threaten to withdraw a tour. You come back from a tour because a certain decision has been taken which is unpalatable. And because you have the money power in cricket, your view will be accepted. That is not the rule of law. Then, consider this. There is a law, there is an interpretation of the law. You follow that law. Retrospectively it is changed. And sometimes the retrospective change is 10 years, 20 years, 30 years. What happens in the meantime? What you have done according to an accepted interpretation of the law. There is no remedy, because retrospective legislation will be followed, will be applied. One further fact of accountability and what the courts do. I said equality before the law. There are two litigants before a judge, the state and the SSE, or two private parties. But when it comes to the state and the individual, question arises that there is something like the law of limitation, that you must take action within a certain period of time. The state files an appeal 300 days late. It is, judges seem to think that yes, it is, I mean, after all, the state can't do things on time. And therefore, yes, we will condone the action. But then say that the Limitation Act doesn't apply to the state. Because consider this, I have won an appeal, I wait for the statutory period, I wait that, well, normal period of condonation would be 3 weeks, 4 weeks, I wait for another month, and then I take a certain course of action, and the state has accepted what has been decided. 300 days later, an appeal is filed, and delay is condoned. Condoned often because the stakes are so high. So many crores are involved. But then that's all the more reason why, if you admit such an appeal, the SSE will be affected to that extent. So therefore again, condoning limitation is, I would think, within limits permissible. Beyond limits, you cannot have 300 days will be condoned for the state. Would you condone 300 days for the individual? One cannot say normally that, well, the state always takes more time. Then provide the Limitation Act for state action, limitation is so and so. So that one knows there is definiteness about the law, you know this is the position. So this is again kind-heartedness, or very often the fact that the judge feels that so much revenue will go waste otherwise. But then one has to be strict about it. This is where I think some question of morality comes in. One feels that, well, revenue may be affected, but if the law is this, it must be accepted. Then one has to balance discretionary power, because the use of discretionary power is anathema to the rule of law. The rule of law must mean it is stated, it is definite, and this must be enforced. But there are of course exceptions where it has to be done, but the citizen's right to that extent must be protected. I referred some time ago to a question of limitation. Let me give you one example where this limitation can work very harshly. I don't want to go into tax law very much, but if I may give you just one example. If you own a piece of land and it is acquired by the government and you get a compensation, that compensation will be assessed. You go up in appeal and you get a higher compensation. That higher compensation also will be assessed. So you get a higher compensation. The period of appealing to the Supreme Court is 90 days. 90 days have expired, no appeal filed. So now you say this has become final, I am returning this amount as my compensation. You file a return, your assessment is made, matter is over. 300 days later, the state says, oh, this was so many crores of compensation, we are filing an appeal. Now there is no recourse, you've already been filed, you've been assessed. There is no provision whereby you can undo that assessment. So therefore, these are cases where great injustice could be done, and the all principle of the rule of law must be to avoid injustice. There is the old English saying, Chief Justice Coke, I think, who said, let justice be done, though the heavens may fall. And the justice, there is no abstract concept of justice. Justice has been, that is, in the days of Empire Jahangir, you had the abstract concept of justice. Today, justice is according to law. One of the great things about the rule of law is public interest litigation. Again, subject to abuse. One cannot deny it. But it is something which reins in illegal action by the government. Now here again the rule of law. It is accepted by majority judgments of the Supreme Court that public interest litigation is beneficial. Suddenly a judge comes up and says, no, public interest litigation must not be there, we must curb it, it is not proper. Now anything which destabilizes a law is to be condemned. I can understand that sometimes a visionary judge, sometimes destabilizing a law which is not just is a great act by a judge. But whenever one wants to destabilize what is the accepted position, one must think 10 times before one does it. So rule of law the concept of the rule of law is that there must be definiteness. One must be able to know what is happening, one must be able to predict what is happening. One great thing about the rule of law is that ultimately, it is the court or the tribunal which is the monitor, is the mediator, is the mechanism by which to resolve that dispute. The main position here is that one must be able to limit oneself to one's own field. The executive should not tread into the field of the legislature or the judiciary, and likewise the judiciary should not tread into the field of the executive or the legislature. Now today when you see sometimes bill litigation and the view which the court takes, one may feel that you are treading into the executive's field. But what is the reason for that? The reason is that the executive doesn't want to take unwelcome decisions. They would rather enforce it as a diktat of the court than as their own decision in the matter. Now this is again, I think, destabilizes the rule of law, because it makes people think that the court is overstepping its limit, not realizing that the court is overstepping its limit because the state remains wholly inactive. The state is not enforcing the law, so the court steps in to enforce it. It gives a bad name to the court. In anything which gives a bad name to the court is not good for the rule of law. One very important aspect of the rule of law is the appointment of judges. The appointment of judges must be done after complete scrutiny and must be done in accordance with the rules. You must have read in the newspapers some time ago, a certain Chief Justice wanted to appoint a certain person as a judge of the High Court. Now the Supreme Court has said that there is always the collegium of judges who will decide the issue. The collegium as constituted did not approve of the appointment. So the Chief Justice changed the collegium. That is what the newspaper report says. And another set of judges was appointed who approved of the appointment of this person as a judge. You must have read some time ago, the name of a judge was proposed in the Punjab and Haryana High Court, against whom a report had been made that he was a go-between for getting certain deals through for certain people. But still, his name was passed by the collegium, even though this was on record. Now, when this happens in the judiciary, one is reminded of the saying that if the salt hath lost its savour, wherewith will it be salted? If in the judiciary one finds this, what is the remedy? Where is the rule of law? A person may say, if this can, but the same judiciary may, if an illegal promotion is made, may haul up the employer. And unfortunately, here again, I think to some extent, the Contempt of Court Act militates against the rule of law to some extent. You must be knowing that in the United States, they do not have any such contempt of court, because they feel in a free society, one should be able to criticize any person. When the important case came up about Ford when he lost that election in Florida, and Mr. Bush won, and Mr. Bush's brother was the governor of California. Decisions were pronounced, and there were open letters and articles that these 9 judges decided, 5-4. These are the 5 judges who were promoted by the Republicans. These are the 5 judges who were Republican Party members earlier, and that is how the decision has been given. In India, if this is said, it will be scandalizing the judiciary. But then, if truth scandalizes, so be it. But one thing must be sure, there must be truth in it. Because they say, even a truth is no defense to a contempt. I would think this again is something contrary to the basic principle of law. One important factor of the rule of law is delay in administering justice. A person is shot in a restaurant in full view of 200 people there. Yet, not one eyewitness is ultimately available when the trial starts after 5 years to depose. A person overruns some people sleeping on the road. The car belongs to that person. But thereafter, after 5 years, there are no witnesses who have seen this. There are people who have made statements, but subsequently those statements are retracted. So where there is such delay, there is always scope for such retraction. So I personally would think one of the factors which go most against establishing a rule of law is delay. Take another case. A politician is accused of something. He is free to contest elections thereafter. Because the principle, unless he is shown to be guilty, he can proceed with his regular work. But again then, must it not be that if one is accused of an offence, of a certain, not a traffic offence, one is accused of an offence, one must take measures to clear one's name quickly. Because here, the politician, he has a vested interest in the delay. Because for 5 years nothing will happen, and in the 6th year people will lose all memory of it. Because as you know, one scandal after another, the second scandal will overtake the first, and the first will be forgotten and consigned to history. So I would think, one of the essentials for a rule of law is that a person who is accused of an offence which carries a certain penalty cannot contest an election unless he has been adjudicated not guilty. Then he will want the adjudication to be done earlier, and he will not be interested in delaying it. Today we find people accused in the 1993 matters. Still the trial is not over. And 1993 to today is 15 years. How many people, you tell me, if you were asked today, what happened 5 weeks ago, what did you do? Would you be able to recollect exactly? You will not. Not because you are not telling the truth, because that is human memory. So if you come after 15 years and say, did you see so-and-so doing so-and-so? And he says, no, I didn't. Then there is no evidence. So delay is, I think, one of the factors which is affecting our criminal jurisprudence and which is affecting, more importantly, the rule of law. This delay must be wiped off. Now, how do you wipe it off? Somebody made a suggestion, there was something in the newspaper, courts will sit half an hour more or 1 hour more. Their courts will function in the vacation. But these are not measures which will curb delay. After all, there is a human mind which can do so much work and not more. And let me tell you, judicial work is extremely taxing, because a person has to take a decision, and he always wants, obviously, to take what is the right decision. He has to think about it. It affects him particularly if you are engaged in, say, a criminal matter, deciding a criminal matter. So I don't think these are solutions. Solution is, yes, increase the number of judges. Solution is, give to the court all the court fees that you collect. Today, profit is made from the court fees, but it is the duty of a state to administer justice, and not that you have to pay the state to give you justice. So therefore, give proper facilities, give proper financial help, and that will enable you to meet this question of delay, not otherwise. Then the courts have to be funded. The right of the court to control the executive must be accepted. One must not in Parliament get away and they say, no, the court has done this. If the court has given a decision which is against a particular action, one should accept it. One can go up in appeal, but that is how you overturn a decision, not by mob action. This is the last page, don't worry. Now, the foundation of the rule of law is the court, and the foundation of the functioning of the court is, if you will pardon me for saying so, is the lawyer. It is the lawyer who puts forward a view. And therefore, when you read that at a certain place they have passed a resolution, Bar Council passes a resolution, the bar at that place passes a resolution, that we will not defend so and so, that is completely contrary to the rule of law. Because every person is entitled to be defended of any offense of which he is accused. And you cannot be moralistic that, no, so and so has done so much wrong that nobody will defend him. The right to be defended. Again, please remember, rule of law again implies that in the defense, it is the duty of the lawyer to place the facts, not to subvert the facts. But he must get the ability, he must have, the accused person must have the services of a lawyer if he so decides. And one example which strikes me, there was a boycott of the courts. Lawyers stood outside forbidding any lawyer to enter the High Court. I know one lawyer who said, no, I don't think this is a correct stand. He went in. He was ruffled extremely badly. Because there is certain action which you can take and a certain action which you cannot take. One must, I can understand in certain circumstances, yes, perhaps boycotting of the court may be justified. But that should be in the rarest of rare instances. Then a question arises about the rule of law in the international field. If you have the rule of law in the international field, you must necessarily not have wars. There is the International Court of Justice, but countries are not prepared to surrender their sovereignty to that international body. And therefore, even though the International Court may decide something, it cannot be enforced. And the United States is one of the prime persons in that. Because the United States takes the view, I hope there are not many American citizens here, the United States takes the view that no, and the American must be judged only by Americans, no one else is fit enough to judge him. So, international law is most necessary, and that is the rule of law which one must have in international things. The rule of law, question arises, is there a relationship between the rule of law and economic progress? If you don't have the rule of law, will there be economic progress? If you have a rule of law, will there be economic progress? There is a general view that there is no correlation as such established. Question arises, do you consider China as a place where the rule of law prevails? If you say no, but that country has made the most fantastic economic progress. Would you say India is a place where there is the rule of law? I think yes. There may be aberrations, but yes. But yet, we have not made that progress. And that is again always the question of balancing economic progress and freedom, economic progress and one's respect for the human individual right. It should promote establishment of a social field where everybody has equal rights. The rule of law would do that. And most importantly, you will find that the lesser the influence of the government, there is economic progress. It is not the rule of law which detracts from economic progress. It is interference by the government with the rule of economics that does not permit a country to progress economically. We have the principle that you must not interfere with religious freedom. Everybody must have religious freedom. But then the question arises, what does the rule of law state? Can there be religious freedom which impinges on my freedom of movement? Can there be religious freedom that you will occupy the pavement, you will occupy the roads? Is that religious freedom? Or is that you are taking an abuse, you are assuming you are taking license to do something which affects another? Religious freedom is something between a person and his God and should not interfere with another person's equally fundamental rights. So, citizens' freedom, there must be a respect for the rule of law, and those who want to propagate their religion must respect that rule of law and not interfere with another person's right of movement. I would think ultimately, in the ultimate analysis, the basis of the rule of law is respect for the law, followed by every person and followed by the state. And respect for the law means respect for everything which the law requires. When you are driving past at 11:30 p.m. in your car and you find a red light, if you don't stop because there is no one crossing the road, you are in breach of the rule of law. Because today one does it at 11:30 p.m. Tomorrow at 11:30 a.m. you will see there is no policeman around, so let me cross the light. So rule of law means a certain self-discipline which all of us must follow. If we don't follow it, if we don't do it, our children won't do it. When they see father going through a red light, he will obviously think there is nothing wrong in it. Today, if one doesn't condemn something wrong, but one talks freely, yes, so much was paid and I got this done. The child is obviously going, that's contrary to the rule of law, but the child will think, yes, that is quite all right. My father does it, everybody can do it. So rule of law means a certain discipline which we impose on ourselves. There is, you will find, I'm surprised, an Indian is in Singapore, an Indian is in Dubai, he will obey every iota and piece of the law there. Comes here on a holiday, and to him, crossing a road when there is a red light or he is of no concern. How can there be such a change? It only means that one, if there is a draconian punishment, you will observe the rule of law. Moral is, we should also have draconian punishment for this sort of breach of the law, which is deliberate. I can understand an innocent breach of the law. But unless the police enforce this, and unless the police inspire confidence, and the police themselves don't do something which is illegal, there can be no hope for the rule of law. It must be, and one important factor for the rule of law is, you are aware of your rights. There must be a recognition of your duties. That is the rule of law. That I know I have to do this for the benefit of society. That is, I think, the basis of the rule of law. Parliament can create the most magnificent laws, but unless they are enforced, they are no use. We have our books full of laws, but enforcement is completely lacking. And when enforcement is lacking, it is the honest person who follows that principle, he is mocked at. You stop at 11:30 at night, you will say, what a fool he is to stop here. But he's just doing what the law requires. So therefore, these small things, I think, these are the basis of a rule of law which, if followed, is going to be beneficial to all of us. And the rule of law is not something new. I think it is Plato and Aristotle, Plato in his book on the Republic, Aristotle in his book on politics. They laid down the basic principles of law. And I will leave you with one thought. I was reading a biography of Plato in the encyclopedia, what they said. And he said Plato, when he was some 29 years old, wanted to enter politics. And I'm speaking now, Plato is, as you will remember, 353 BC. But he felt that politics is no place for a man with conscience. Thank you.
Since we've had many Manthans in the last 30 months apart, but I think today has been a day when we have had today is the day when we had for so much of erudition that in about 45 minutes or 1 hour, I think he has touched upon every aspect of the rule of law. That very rarely do we have such an opportunity. I think we must thank him for that. But we have different rules here, sir. And we start it now, and the floor is open. We are not asking questions.
May I have some questions? So you said that everybody has a right to defend and a right to a lawyer. So what is your view on Nani Palkiwala returning Indira Gandhi's brief when she declared an emergency? Nani Palkiwala had accepted the brief to fight Indira Gandhi's disqualification case and returned the brief on moral ground when she declared an emergency. So how does it square up with what you said?
But Nani Palkiwala did not say that no lawyer will defend her. No. She had the liberty to go to any other lawyer.
Other lawyer said the same.
No. A lawyer must also have certain personal rights. He may feel in a case that I cannot argue this case for some reason. I am not, therefore you cannot go to some, one can always go to another lawyer. But when the bar passes a resolution that you will not, that means you are shutting the gates of getting assistance from a lawyer to that person. And therefore there may be cases where one's conscience is so moved that one feels that yes, I must do this. And since you talk of the emergency, I think the greatest act of courage in that emergency was of Mr. Fali Nariman. Emergency was declared on 25th June 1975. On 26th June, he sent in his resignation as Additional Solicitor General. So, I think a lawyer also has certain rights where he feels he cannot, for certain reasons, supposing you believe in vegetarianism, let me give you that example, and somebody wants you to argue for that there must be a protection for something which goes against your belief in it. Well, you probably would be justified in returning it. But you cannot return a brief only because either monetarily it is not paying, you cannot return a brief because you do not find it interesting. You must accept a brief where you practice, but there are certain rights of a lawyer also to return a brief.
I just want a small clarification. You mentioned that rule of law, there should be no delay. And you gave the case of this Jessica and then also of the Nanda case of running over. Is that delay, or it's just that there is certain corruption at high levels and they wouldn't allow the case to come in? It was a deliberate attempt. I wouldn't call it delay. I would just call it intervention of the powers for very powerful, the rich and powerful.
Yeah, I see your point of view, but please remember that there are criminal cases of ordinary people coming up in 2008 when the offence was committed in 95 or 96. They do not have the power to delay anything. So, there is delay in the system. People abuse that, yes, perhaps to cause greater delay. But there is fundamentally delay in the system itself. And somebody may use that power to delay it further, if you may call it, but delay is there in the system.
So my question is about perjury, as in when you talk about delay. If the law, the rule of perjury is applied, do you think that the delays will actually stop, as in people will not retract their statements?
Right. Now, how do you establish perjury? Because previously he has made a statement before the police, and thereafter he retracted. The statement made before the police is not admissible. Question then comes of you can take steps for perjury against him, but then you will have to establish that yes, this statement was made in these, he was aware of all this. So it is difficult. You are right. If one takes action in perjury, it may curb to some extent. Judges have ordered in a case where they have acquitted an accused also, they have ordered a perjury action against a witness. You are right, but unfortunately, it is not proceeded with as often as it should be. You are right. It should.
From what you said, it is evident. I'm here, Ajay here.
Yeah.
Yeah. From what you said, it's evident that it's important to promote the rule of law as much as you can. The better the rule of law, the more civilized the society is. Any thoughts on what really can be done, either by state or by society or individuals, to really promote in practical terms the rule of law?
Yeah, I think one thing is strict enforcement of the law without bothering about who the person who is to be proceeded against. Because if you make one or two or three examples, then people will get the message immediately. But when people feel, as this lady correctly pointed out, that one can get away with whatever one does, then obviously that creates an inertia in a person to follow the rule of law. Rule of law also must mean that the law must be reasonable. Let me give you one example. At one point of time, the tax rates were so high that people thought I cannot pay so much tax. And you created a culture of people not paying their taxes properly. That it takes time. You have lowered the rates of tax. Compliance is better, but it takes time to weed out that once you've created it. So I think personally, yes, quick, immediate enforcement is one solution which one can think of to do it immediately. Another is an example. Example set by a person will carry the matter much further. Take a common case. You see a person spitting on the road. Do you go up to him and say, please, this is not the right thing to do? I make it a fetish to do it. And let me tell you, only once has a person become violent in that. Otherwise, they always accept that, yes, I'm sorry, I've done something wrong. So I think if we go out of our way to tell or try and do what we can, what we think is the right thing to do, then I think it does help in the long run. Because you beat a stone 100 times, they will make a dent on it. You beat it once, it will not make a dent on it. So I think all of us have to do something.
My question is regarding this cost of litigations involved. This rule of law, there should be affordability for common man. But by and large, we see in this country, the cost of litigation is very high, seeing the visible and invisible cost of lawyer system, etc. So what is the sanctity of rule of law when most of the people, they prefer to suffer in silence rather than seeking justice with the system?
What do you mean invisible cost? Well, as far as the invisible cost is concerned, if you make up your mind that I will not incur that cost, that will be a solution. Because, again, let me tell you, if a person knows that here is a party who will pay an invisible cost, let us take simple case. You have to get a copy of a judgment. If you have the reputation that, well, you will pay something to get that judgment early, that invisible cost you will always have to incur. If you say, I am not concerned, you send it to me whenever you want, that invisible cost will not be there. So one must make up one's mind as to what. You're right, insofar as fees are concerned and they are high. But then, again I would think, I hope I'm not speaking of utopia, but in normal course, a lawyer, what he should do, I'm not saying that it is practiced, a lawyer should not refuse a brief only because the fees are not adequate. But a lawyer may, if he thinks fit, refuse a brief for other reasons. Now, again, cost is high, you are absolutely right. But also remember, I'm not justifying high fees, also remember that even a lawyer has time which is limited. And he feels that one way of limiting work which I have is if I charge a higher fee. You may say that is not proper, but then also look at it from a personal point of view of the lawyer. So that there is this of higher fees, but there are certain reasons. I hope it doesn't sound that I'm making excuses for high fees charged by lawyers, but there is this issue, and therefore, and also remember that if he has to devote his mind, if he has to practice his mind, and he values his time on a certain basis, that is what a free market is about. And there are always lawyers available. There are lawyers who are starving. There isn't there is any shortage of lawyers. Only question, I think, between a lawyer who has reached a certain position and another who is not, is that that person there got a chance at the right point of time. The lawyer who hasn't succeeded is probably as good, but he never got a chance at the right point of time. And if you don't get a chance at the right point of time, frustration sets in, and then one goes downhill. So lawyers are always available. It's a question, and ultimately, I don't think, though the general perception is that lawyers win cases. A case is won on its own merits. A lawyer may perhaps help it a little in that rare 2% or 3%, he may make a difference. But by and large, I don't think a lawyer really wins a case. The case is won on its own facts. Even if a lawyer who is not as competent is there, those facts will emerge. Because the truth comes out, whatever one is to talk about. And the judge also is conscious. If he feels that a lawyer is not putting forward a case, the judge will try and see to it that his point of view is properly focused.
But a bad lawyer may sometimes lose a case.
Possible. A bad doctor may kill a person. A bad engineer, a bridge may fall. There is obviously, I'm not saying there are no bad lawyers, of course there are. But everybody is good, everybody is bad. In life that is so.
Sir,
Haji.
I would like to put it this way, that nowadays we are not seeing rule of law, but it's only rule of law. People law with intent and content. And my question is, sir, is that in these days of rule of law being broken by the people, very people who are making the law, and how far the principle that ignorance of law is not excusable is valid?
No, but people in position who break the law, I don't think they ever say we were not aware of the law. They just brazen about breaking the law. You're right, ignorance of the law is no excuse, that's an old saying. But in today's time, perhaps it does not hold, is not wholly correct. Because there are so many laws of which you may not be aware. That where there is a breach, you may sometimes find, oh, I did commit a breach of this law. If you suddenly come across a law, because I was not aware of it. So, it is true, that is the common saying, ignorance of the law is no excuse, but there could be cases where one says, I was honestly not aware of it. A judge would take that into account, depending on what type of it. You cannot say something which is obviously not legal, that I was not aware this is not permissible. But there may be certain technical breaches for which one could say that no, I was ignorant of what the law is. But cases which you put forward are not of ignorance of the law, they are in deliberate defiance of the law in the knowledge that this will go through. There are people who get away with saying that I received gifts of some 30 crores of rupees. And people just came and just prostrated themselves before me and put this money there. Now, sometimes they get away with it. Sometimes that is accepted. Maybe accepted by a tribunal, maybe accepted by a court, but that doesn't fit in with the normal concept.
After all the after all the explanation of the rule of law, what we can see, I don't know how ordinary human beings like us can continue understanding law in the manner what you have explained. It's too elaborate. I would just like to know from you whether a correction or a penalty would be a method which would make people follow more of the rule of law.
What do you mean by correction or penalty? Sorry, is it correction or penalty?
Yes.
No, what do you mean? Not levying a penalty and,
Yes.
and correction?
Just explaining and
Yeah, I see.
Counseling.
Yeah, that may work, but I don't know. I'm cynic enough to think that in the long run it may not work in our country, because unless people take it in their stride, then what is it? If I'm caught, I will pay this fine. What does it matter? And look at this. That is encouraged. Give you again another example. People pay their taxes. Every 10 years or 15 years you come across with a voluntary disclosure scheme. So a person says, yes, okay, I'm avoiding it. When it comes along, I will pay much less tax than the person who is next, who has paid these taxes honestly, and I will get away with it. So therefore, it is just correction may not be a solution. It is morally very high, but I do not know whether it is really a solution. I think penalty is something which does make and which sets an example.
During your talk on one place you said that under extreme cases the judiciary can change the law, but again you went back, said that under no circumstances should the judiciary change the law, but they should just follow or implement the law. So isn't it a very subjective thing? How do you decide what are those extreme circumstances?
No, judiciary never changes the law. Judiciary gives its own interpretation of the law, a liberal interpretation which may carry it forward. But they are after all ultimately enforcing the law. A judiciary which wants to change, you cannot, it is for Parliament to change the law. A judge cannot change the law, but he may interpret it in a manner which makes it more humane, which makes it more acceptable. That is how I would look at it.
Just a continuation of his question. During your talk, you said that rule of law has to be strictly followed. Now, I'll give you one example. That there was this case of the four.
Can you put on the mic?
Push it all the way.
Yeah. There was this case of the four JMM MPs supporting the PV Narasimha Rao government, and then each of them was paid 40 lakhs of rupees. And fortunately or unfortunately, this amount was put in their bank accounts. So it was more or less a conclusive evidence that they had taken this money to support the government. Then one of the four MPs became an approver, so he was left scot-free. And then the case went on for almost 10 years. And then finally, when the case came up for hearing, the Delhi High Court, if I am not wrong, it said that these four MPs, they have taken the money to do something inside the parliament. So, because they enjoy immunity, we can't really do anything about it, though they have taken money for that. So, in a way, the court was strictly following the rule of law. Now, how far is it correct, or should the court have done something to really punish these people and then go beyond the strict following of rule of law?
You're quite right. Why do you stop at Delhi High Court? The Supreme Court did that also. That for an action of a member of parliament in parliament, one you cannot take. But I think you are right in why public conscience is moved against it. But the principle is this, that it is for parliament to take action against those people. Parliament can also become a court in itself.
Parliament is a party here.
Right. Members are there. Please distinguish between parliament. A parliament is innocent.
I agree.
The members may not be. So it is for parliament to take action against them. That is the philosophy. And they feel that otherwise the court is intruding on the including on the deliberations of parliament. I think it's a wrong thing. but this is the basis of it. And what shall I say, the congruous position is, or the incongruous position is, that the person who gave the money can be charged for bribery. But the person who took it for doing something in Parliament cannot be charged under the normal law. But that is why there is a great move that Parliament should define its privileges. But Parliament has always, for the last 57 years, resisted defining its privileges. Because if you define your privileges, you cannot widen it. But if you keep it amorphous, you can always say this comes within my privilege. Just now you must have read of a member of Parliament who entered an aircraft late and who was offloaded. And he said, I will take it up as a breach of privilege of a member of Parliament. What is it? The member of Parliament is entitled as of right to go into the cockpit and to talk. We do not know who's right. Whether he was unjustly offloaded, then it is not a question of breach of privilege he should take. He should take the recourse to civil court that he was unjustly offloaded. Claim damages from the pilot. But one cannot shelter again under it and the privilege of Parliament. But I do see, one does feel that the privileges of members must be restricted. And that is why I said, you must give them privileges which are absolutely necessary. If they need protection, yes. But you cannot give them Z security just for the sake of satisfying their own need.
My question is, can I say? My question is that an essential premise of rule of law is accountability, which leads us to right to information. Much is made about the debate about the Chief Justice of India and the RTI. And secondly, sometimes this RTI is not practically feasible, like students wanting to see the examination papers. So what do you say about that?
Right. I think their right to information is a good principle, but there are limitations. I will give you one example again. There was a big debate as to whether one can obtain the return of income filed by a person. And it was held, no, you must give it. I would think that is wrong, because in today's time, that may be subject to a lot of abuse. On the other hand, the view is that if the return of income is known, then anybody can come and complain that, look, his return is only returned so much, it should be more. It's a question of balancing. The Chief Justice has said that his view is that the court must not be subject to the right to information. My own view would be, in the long run, it must be subjected to, but time must elapse so that it is established, some norms are established as to what comes within the right to information and what does not, and what intrudes on privacy. I think there has to be some line.
Yeah, I wanted to ask about RTI and the Supreme Court. I think you already answered it.
Ladies always first.
This matter of Raj Thackeray actually highlights the issues which society faces. You have a politician who's making patently unconstitutional claims and asking his followers to do that, and he himself is practicing that. You have a weak state which is not doing anything about it. I do not even know whether the judiciary is strong enough to do something about it. What is it that society can do or should be doing to make sure that these things are contained and corrected and perhaps do not recur again?
I think if one takes it up in a court of law, whether the judge is strong enough or not, but I think the judiciary itself would then feel that they are being exposed, that the judge could take action against a person who is not able to have muscle power but could not do it. And there are judges, let me tell you, who will not cow down. There are judges who will take action. There may be judges who may not, I'm not saying, because after all, every person is a human being. Because he is a judge, he doesn't become a superhuman being. But it is a question of your human strength and your ability to withstand pressure. But I think a complaint has been, a state is weak. I would agree with you, a state is weak. It is also a case where the state thinks it is politically proper for it to do it because it gets its political support. So it's not just a question, it is not just a weak state, it is a cunning state.
My question is on the development of the internet. Many societies, many the civilians have all worked together without the rule of law, but yet have come out with a product which I think together they're maintaining it, I would say without the rule of law, but with minimum interference of law. Isn't it an example of that the rule of law should be supreme, and but law, I mean, example of where law should be minimum?
Yeah, you are right. There is no sense in flooding the book with several laws, some of them relevant, some of them which our book, if you go through, some time ago, Parliament I think repealed some 85 acts which had lost all, and there are probably another 185 which they could repeal. So the lesser the number of laws, more strictly enforced, will be conducive to the rule of law. Larger the number of laws will induce a feeling that, look, so many laws I cannot possibly comply with all of them. You are right.
So I would like your views on this. Hello, I would like your views on this, sir. So Mr. Nurani or Mr. Goreval, I forget one of the two, he has observed that High Court judges are less prone to political influence than Supreme Court judges, and High Court judges are giving decisions which are very bold as compared to Supreme Court judges. Would you like to comment on this? Is it true?
Well, I think that remark was made in the context, but particularly the emergency, when the high courts all over the country held that no, the emergency was not properly imposed, and the emergency doesn't give a right to a person to shoot another. Unfortunately, the Supreme Court in a 4-1 verdict, out of the 4 people, 2 became Chief Justices thereafter. And thereafter, when they became Chief Justices and after they retired, they preached morality and what is the correct thing to do. But you're right, the one person who dissented was the late Justice H.R. Khanna. And you're absolutely right, yes. But I would not, from that I would not take a normal rule that yes, the High Court judges are more forward-looking than the Supreme Court. It's a question of who were the judges at that particular point of time who decide. Maybe some other judge in the High Court may have decided it someone. And after all, always remember, a Supreme Court judge is one person who was a High Court judge. So how can you say he sheds it? But yeah, there I agree with you. I think closer to Delhi, it is not good. And since you raised the point, something which agitates me a lot, if I may be pardoned for referring to it, the headquarters of the Income Tax Tribunal are in Bombay. But the President sits in Delhi. Now, the President should be where the headquarters of the tribunal are. The king must sit where the throne is. And in Delhi, you are subject to influence. You are right, the further away you are from Delhi, the more independent you will be. But that is it.
And as an aside, we are an extremely ungrateful society in not having built a statue to Justice Khanna.
You are absolutely right, but I think the tributes which he received thereafter, perhaps Cicero stamped that why is the statue not there, rather than why is the statue there to him. But certainly that was the most bold decision, and he writes that I knew that by giving this decision, I was foreclosing my right as the Chief Justice of India. And it did happen.
I think we are running out of time. Any more questions? Mr. Dastur has to leave.
Only last question, sir. What's your view on judicial reforms happening in this country?
What do you mean, what's my view? And what particular aspect are you referring to?
No, there is a paper on good governance being considered or approved by the Prime Minister's office, which internally contains some judicial reform package also.
Yes, I think so. For example, one of the things which has been hanging fire for a long time is that you must have the appointment of High Court judges by a larger council of people who would nominate. I think it's a good thing because human being what they are, you cannot leave everything in the hands of one person. One more thing, since you referred to judicial reform, we have now started this practice of the Chief Justice of a High Court being from another state. So the Bombay High Court, this practice started somewhere in 1990s, 89-90. Bombay High Court till 1990 had the same number of judges from its inception in 1865 till after 1990 to 2008. Because Chief Justices come for 3 months and 6 months and then they are promoted to the Supreme Court. And obviously, if you are from Andhra or you are from Chennai and you come to Bombay, you don't know what the traditions of that court are. So I think this is a practice. Judicial reform must mean that you cannot have a Chief Justice from outside. What is the function of the Chief Justice? To appoint district judges as High Court judges. Now, unless he has functioned in the High Court, how will he know the performance of district judges? He is then dependent on other judges of the court. So therefore, the Chief Justice must necessarily be from the same High Court. I think that is the point. This having a Chief Justice from outside doesn't serve the purpose at all. But representations have been made, but no one has accepted it. And the judges themselves don't want it because it gives an opportunity to a person to become a Chief Justice at a place where otherwise he may not have become a Chief Justice. You are in Rajasthan, you are the senior most judge there, but your Chief Justice will probably retire after you, so one won't become a Chief Justice. You get a chance somewhere, a vacancy is there, you go to into Kochi and you sit there as the Chief Justice. So this is something which the judiciary has accepted. The judiciary has, take another case, since you refer to it. Supreme Court functions only in Delhi, which means that for a litigant from Cochin he has to go to Delhi. And unfortunately the court sometimes adjourns a case at the drop of a hat. So a person who goes there, stays there, comes back. So is there not a very good case for the Supreme Court to sit in various places? In Bombay, in Calcutta, perhaps Hyderabad, Bangalore, wherever one chooses. Because justice must come to the people. What is the excuse given? That then there will be different judgments pronounced. But in today's day of communication, you can't say that a judge sitting in Delhi won't know what his brother judge has decided in Kochi. And even so, are there not dissents? Are there not different views taken by different benches? So therefore, this is one thing of judicial reform, which you say Supreme Court must function at benches because that will be convenient to the litigant. Judicial reform, since I'm sorry for, I am in a hurry to go, but there are certain things which agitate me. Judicial reform means that the litigant must be the first, then the judge, and then the lawyer. But what do you find? Go to the Supreme Court of India, you will find the judge has a fine chair, the lawyers have 4 rows of chairs, but the litigant has to sit in a small cubicle right at the end. So his case is being argued and he is 15 feet away from his lawyer. So reform of justice must also mean it must look to the convenience of the litigant. Judges today, matter is fixed, your matter is 15th on board, the litigant is expected to be present when it is called out. But it may never be called out in the day and the litigant loses his day's wage for that. So there must be some court management that you at the beginning keep 3 cases, 4 cases which you think will occupy and let the litigant otherwise go. So there has to be court management, yes, it has to be there, it is for the litigant that the courts exist and it is not as if the litigant exists for the court. But you are quite right, judicial reform has to be there, one's attitude has to change.
So friends, we come to the end of a very active, engaging Manthan session. I think, I'll repeat what I said in the beginning of this debate, that this has been one of the best Manthan sessions we have had. It's a pleasure to listen to someone of such eminence, and someone who is an expert, and he set us thinking. And I'm sure in the Manthan discussions on the web, we'll shift from God to law.
Well said.
I thank you, sir. As a token of our gratitude, may I ask Mr. Parik, a fellow Manthanite, to come and give us. Thank you, everybody.
Most grateful to you.